Okay. We are live. Let's go on the record on, and I think the parties have agreed that my court reporter isn't able to be here at the moment, so we're going to be able to use the YouTube as a way for her to go ahead and do the transcript. Is that okay with everybody?
Yes, Your Honor.
Okay. Let's go on the record on DC 205795, Casey versus, I can never, Mariskandari. Counsel, make your appearances.
Your Honor, my name is David Kassab. I represent Amir Mariskandari, the defendant.
Your Honor, Brandon Fuqua on behalf of plaintiff Kevin Casey.
Let's proceed.
All right, thank you, Your Honor. So the defendant has filed two motions that are before you today. The first is a conditional motion for leave, and the second is a motion to dismiss or exclude testimony. Both motions essentially require a clarification from this court as to whether the scheduling order that it entered on July 13, 2020 is applicable. And Your Honor, if I can share my screen, is that appropriate?
Yeah, let me go ahead and, there you go.
All right, thank you. Your Honor, this is the scheduling order that I'm talking about. This scheduling order defined the ITS, or the initial trial setting, as January 25th, 2021, and contained various pretrial deadlines. Paragraph 7 of this order identifies some of those deadlines. And it states that 30 days before the ITS, or by December 24, 2020, the parties shall exchange certain pretrial materials. After that order was entered, this case went up on an interlocutory appeal. The trial proceedings were automatically stayed, and all of these pretrial deadlines that are contained in this order lapsed. The case was not remanded until July 29, 2022. Once remanded, the court gave this case a new trial setting of January 3rd, 2023, but did not issue a new scheduling order. However, it did issue a notice, and this notice was entered on November 18, 2022 of last year.
Is that calendared? Isn't something we put on? That must have been something your office.
Sure, and it is, Your Honor. This is what my staff put the calendar on there to calendar any deadlines that are in this order. Whenever a court issues an order, we always, it's our system to calendar it, which I'm sure is typical.
Okay.
This notice stated that completion of discovery, presentation of pretrial motions, and other matters relating to preparation for trial are governed by the Texas Rules of Civil Procedure. So based upon that, my staff did not calendar any deadlines from the July 2020 scheduling order. On December 3rd, 2022.
Are you saying this paragraph would trump any type of scheduling order?
Your Honor, I think this paragraph made clear that the prior scheduling order, which had pretrial deadlines in it, no longer controlled, and that preparation for trial was governed by the Texas Rules of Civil Procedure. That was my understanding of it.
Okay.
So on December 3rd, 2022, the plaintiff filed his pretrial disclosures in this case and allegedly served those on me at my work email address. And I say allegedly because my work email address was down on that date due to a nationwide outage by Rackspace. I don't know if the court has read in the news at all, but Rackspace is a service provider for our email, our work email, and they had a nationwide outage, so we were not getting any email address or any emails at that address. On that date, December 3rd, I notified counsel for the defendants through my Gmail account, which is my personal email account, that my work email was down, and we were talking about settlement, and I said, hey, by the way, my work email is down, and if you need anything from me or want to discuss this matter further, please email me here at this address or call me on my cell. Although I gave them that email, they did not send me the disclosures that they filed that date. They sent it to my work email address, never forwarded it to my personal email address, so I didn't know about it. I didn't know it was filed. prior to that, I didn't find out that the disclosures were filed until December 15th. That same day, December 15, 2022, I sent an email over to Mr. Hopkins and Mr. Fuqua, letting them know again that my work email was down and asking them if they would go ahead and send me, stated I want to confirm that you did not file or serve anything to me at my kasab.law address during that time. If you did, I did not receive it and would ask that you send it to me again. So all I received in response to that email was an email from Mr. Hopkins stating, offering for him to have his staff assist my staff with checking the e-filing system. I didn't receive anything that was filed until Friday of last week, is when they finally sent me a courtesy copy of everything that they served on me. And they did not do that until after I pointed out this email in the reply that I filed with the court. So that leads us to the two motions. That background leads us to the two motions that are before you today. The first is a motion for leave where we're asking the court, number one, to provide clarification as to whether or not the 2020 scheduling order applies. If it does apply, we would ask that the court grant leave for the defendant to file his pretrial disclosures, which were filed on December 15th, and leave to include with that filing exhibits at trial that include my billing invoices. So Mr. Casey essentially provides two reasons as to why the leave should not be granted. One is that Mariskandari did not demonstrate good cause, and the second is that they would be prejudiced if leave is granted. Again, we think that the court's notice made clear that the rules of civil procedure would govern and not that scheduling order, and so therefore we don't think it applies. But even if it does, then Casey cannot show prejudice from a 13-day delay after the deadline. These documents that we filed were essentially billing invoices that they've known about since October of last year. They were updated between October and December, but they've known that I was going to testify as an expert on attorney's fees and rebut any testimony provided by the plaintiff's expert. And they've known about the billing records, and they've received copies of those invoices on December 15th when I filed the disclosures. So we don't think that Casey can demonstrate any prejudice by the several day delay, especially given that trial in this matter was reset from the 3rd to the 17th. So that's with regard to the motion for leave. With regard to the motion to exclude, it's our contention that if the 2020 scheduling order does apply, then Casey is guilty of violating it. Number one, because he was required to provide and exchange materials with me, and I didn't receive those materials until Friday of last week. And although Casey says that he served those, I've requested proof of service, he has not provided those to me. The other failure to comply concerns paragraph 7 of that scheduling order, which required Casey to submit materials stated in Rule 166 by the Thursday at 4 p.m. before the initial trial setting. If the court is going to use the January 3rd trial setting, Casey was required to file those materials by December 29, 2022. And Casey failed to do that. And the order provides that if a party fails to do that, it will result in dismissal or may result in dismissal for want of prosecution or some other appropriate sanction. Now, Casey argues that the date in the trial setting date is actually January 17th based upon the court's granting of the continuance. So the deadline to file the materials is not until January 12th. But the old scheduling order states that a reset of the trial setting does not alter any deadlines, absent order and agreement of the parties. And if the court will recall, at the last hearing, Mr. Fuqua objected to any of the deadlines in the scheduling order being extended. And on pages 13 through 14 of the transcript, and I could pull it up here if the court would like me to, but there was a dispute as to whether or not the deadlines would even apply. And so the court made the agreement, or the court stated, quote, it would like an agreement between the parties that the continuance does not change any deadlines in the scheduling order, to which Mr. Fuqua said that he agreed. And after I reiterated that I didn't think any deadlines applied, the court said, how about if any? And I said, okay. And so if those deadlines apply, then Casey missed the one requiring him to exchange Rule 166 materials. So, Your Honor, those are the two issues that are before you today, and we would respectfully ask the court to make the conclusion that the scheduling order from 2020 does not apply, but if it does, then to grant leave and to also sanction Mr. Casey by excluding his evidence that did not comply with the scheduling order.
Response?
Yes, Your Honor, and I'll try to be brief because I know that we're a little behind schedule. So I think that we're in agreement that there, at least at one point in time in this case, there was a scheduling order in place, and we believe that the scheduling order that the parties jointly submitted is still in effect. That 30 days prior to trial, there was supposed to be an exchange of trial exhibits not previously produced in discovery, and 30 days before trial at that time would have been December 2nd. On that date, we timely served our exhibits on defendant. Defendant took no action. And importantly, we e-served our exhibits. So it's not just my word, Your Honor. We can actually go into e-file Texas and see that they were served. In fact, we repeatedly asked opposing counsel if he was familiar with e-file Texas because it was possible for him to personally pull down at any time, regardless of any email issues he may have, those exhibits, regardless of whether they're filed or not, he could pull them down as they were served. And so when we offered the assistance of our staff to assist his staff with pulling those documents, so he didn't have to take our word for it. He could pull them themselves. He rejected that offer multiple times with, well, colloquy I won't repeat for the court. But in any case, we timely served our trial exhibits on December 2nd. However, the motion before the court today is essentially asking it to overrule our objections we haven't yet made to defendant's trial exhibits. And so I think it's premature and procedurally improper, but to the extent that the court
so let me just make sure I understand what the scope of this dispute is you guys, so Mr. Fuqua, how do you say
Fuqua, Your Honor?
Fuqua, you're claiming Mr. Kassab, or at least he's saying you're claiming that his exhibits were filed late.
Correct. He is saying that his exhibits were filed late.
His exhibits were filed late.
Yes, Your Honor.
He's concerned that you're going to try to strike them.
Correct. Correct.
But you haven't done that.
No, because our 166 pretrial filings that we're jointly putting together actually due this Thursday. So it actually hasn't even come to pass. We're actually together collaboratively working on the 166 filings, and we'll likely file those this Thursday or before. And I hope I'm not getting ahead of myself, but yes, we will be moving to strike as untimely his exhibits because they were not filed 30 days prior to trial. But we haven't yet done that. So I think that as an initial matter, this whole motion is premature. And
let me just tell you how I generally approach this, because it sounds like this isn't really ripe, is in most cases, I am not going to strike exhibits because they're filed late. Now, if they never produce it in discovery, that's a whole different matter. But if it's a situation where they filed it late and it's at least, a reasonable amount of time, I am not super strict on that. And so you can file whatever you want to, but I'm not typically going to allow, I'm not going to strike either side's exhibits if there hasn't been a strict compliance with the requirements to turn over trial exhibits. Now, there are some cases where they're very large cases, they're very complex, and there's a lot of moving parts. I'm not saying I've never done it, but it's pretty unusual. Now, that doesn't mean if they haven't been compliant with discovery, I'm much more likely to strike. If you know, hey, I have this exhibit, I never turned it over, I'm much more likely to strike it. So I don't know if that helps in all of this. It does feel like this is all a little bit premature, but
yes, Your Honor.
And Your Honor, I can tell you why it's not premature is because when I sent that email asking them if you know anything was filed and if there were disclosures, so the problem is there was never any request for disclosure sent by either party or any discovery sent by either party. And so when I sent that email asking, hey, you know, is there any filings, pretrial filings? What do we need to do to prepare for trial? And they said, you know, we filed our disclosures timely. You didn't file yours timely. And so we're going to move to exclude them. Then the first thing I did is file that motion for leave and file those pretrial disclosures. And then I wanted to bring this to the court's attention before the trial setting, just in case. And in their response, they ask in their prayer to respectfully deny the motion for leave, prohibit the use of Mariskandari's untimely exhibits at trial, and award Casey other such relief. So, you know, I mean, that's why it was brought up to the court now. I'm fine if we want to, you know, kick the can down the road until trial, but I would like to know, you know, in preparation for trial, if I'm going to be able to testify as a rebuttal expert. And
I kind of feel that if you guys didn't exchange discovery and you didn't, you know, send even disclosures in this case, that this is going to be kind of like the Wild West, and you guys are going to, you know, you're going to have to just be prepared to try the case.
Mm-hmm.
Yeah, I mean, and Your Honor, it's under the old rules as well. So it's not like I had an automatic disclosure that was due. So.
Right. And so that's the problem. We were just trying to avoid trial by ambush.
Did one of you guys request a court reporter to show up for this?
No, Your Honor.
Jessica Jefferson?
No, that's not mine.
Okay. I mean, I guess it's okay if you want to, but I thought we had an agreement.
Yeah, it's not my court reporter, Your Honor.
Okay.
And then
do you know who that is? Jessica Jefferson? Do you know who that is?
I do not.
No, Your Honor.
Okay. All right. So what do you want me to sign today?
Your Honor, I would like the leave, I guess, to file the pretrial disclosures to the extent the court believes that the 2020 scheduling order applies, and I was required to submit that information by December 2nd.
Okay.
And so I would just ask that either the court not rule today or deny it, because if the scheduling order applies, it wasn't timely. But in any case, the court can take all this up at the same time it takes up all the objections to all the exhibits that are offered for trial at status conference. So it can all do it together, not kind of piecemeal. To be clear, we haven't even made our objections. We haven't presented all of our objections to the exhibit to the court.
I do feel like to make it clear, and I understand, did you submit an order on a motion? I think it might be useful for me to do something in terms of granting leave, at least to, is that even necessary at this point?
I don't think so, because the requirement in the scheduling order is to exchange exhibits. There's no requirement to file them. And so the whole basis of the motion for leave to file anything, I think, is just kind of a red herring. Mr. Kassab can file whatever he wants to. What we're essentially talking about is whether or not the court's going to allow him to use certain evidence at trial. And so I think that the court would take all that up before trial when it deals with all the exhibits, not decide on kind of before we've lodged our objections, what those, whether or not
That's
one
fine.
piece of exhibit can come
I'll
in.
roll on it at the time. I just want to make it clear that if you didn't exchange discovery, it's kind of the Wild West, and you're going to be able to I still encourage you to exchange exhibits beforehand, but anyway, all right, guys, have a great day, and we'll see you at trial.
Thank you, Your Honor.
Your Honor, do we know if we're going next week?
Let me see. You guys for the 17th.
Yeah, the 17th. I'm sorry.
Yes, Your Honor.
Right now, you're number 3.
Great. Thank you, Your
Okay.
Honor.
That's all we know at this point. So,
Okay.
and we,
All right.
like last week, we tried 2 cases. I don't know how long those first 2 cases are, but at the moment, you're number 3.
All right.
Understood.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, guys. Bye-bye.
Bye-bye.
We have an extra court reporter here. Miss Jefferson, what are you here for?
I was scheduled for a 3:15 hearing with this Zoom.
Did someone hire a court reporter for this? Who
I'm through
hired you?
Esquire.
Did someone-
Esquire deposit. I'm not sure.
Mr. Easton, did you hire a court reporter? We have a court reporter.
I understand. No, Your Honor, we're here for the 245 one. So she's here for 315.
Ms. Voigt, did you hire a court reporter?
No, Your Honor, I'm here for the 245 as well. I did not hire Ms. Jefferson.
Mr. Smith, did you hire a court reporter?
I'm sorry, Judge. There was some commotion right outside of my office. I did not retain a court reporter for our 3 o'clock hearing.
Okay, we have a 3:15 hearing. I guess we'll kind of cross that bridge. You're welcome to be here, but don't really need it to court reporters, but
Okay, I'll come back at 3:15.
okay.
Okay.
Thank you. All right, so both sides are here on the Mercado versus Green case.
Yes, Your Honor.
Yes, Your Honor.
Let's go on the record on DC 21-17955, Mercado versus Green. Counsel, make your appearances.
Steve Easton on behalf of the plaintiffs, Elizabeth Mercado and her children.
Stoli Voigt on behalf of defendant Eric Green.
Was Mr. Smith on this case as well?
No, Your Honor.
No, Your Honor.
Okay, let's go ahead and proceed.
Yes, Your Honor, this is defendant's motion. This is a motion to compel. Defendant is in receipt of plaintiff's discovery responses as of this morning, though the requests that were served on plaintiff were from September 20th, 2022. Defendant is now amending its request and requesting specific information on the record from these discovery responses because plaintiff's responses contradict information that has been produced. Further, defendant would like for it to be stated on the record that the verifications for these discovery responses are signed and dated November 4th, 2022, yet they did not get served to defense counsel until this morning. Which is the morning of the motion to compel hearing. So first, defendant is still compelling the completed response to interrogatories for minor Elizabeth Hernandez because the one provided by plaintiff was copy and pasted from Emilio Hernandez's responses. So defendant needs the responses from Elizabeth as requested. Second, defendant requests the court to order the production of the following information from Elizabeth Mercado's request for production. The first is RFP 1, which is seeking
Can I
auto
ask a quick
insurance.
question? So first off, Mr. Easton, were you untimely in filing your responses to discovery here?
Yes, Your Honor.
Okay, so you waive all your objections.
Yes, I did. I didn't file any objections.
Okay,
That's correct. Specifically, though, we're compelling the responses to those interrogatories to be correct for the plaintiff that it was sent to. And then these RFPs, there's 4 specific RFPs from Elizabeth Mercado's request for production. One is RFP 1, which is seeking the auto insurance policy for this matter. Plaintiff had stated in its response, there were no items responsive to this request, yet the police report in this matter has an Allstate insurance policy with a policy number listed. So plaintiff
Mr.
needs
Easton, does your client have insurance?
I think she just has the basic insurance. In response to Ms. Voigt's comment, yes, we're trying to get that policy. The delay usually comes when we get them to come in to do the answers. And then they're supposed to go out and get us these documentation. I think on this case, the Allstate policy was not produced, and we're in the process.
You're going to need to produce that within 14 days.
Yes, sir. I understand. Also, we need to produce, client has indicated that although she doesn't have health insurance, her husband does, And we're checking to see whether or not they're being covered under that policy as well. And we're trying to get a letter from them to produce.
You're gonna have to produce any insurance coverage that covers your client, health insurance coverage within 14 days.
Yes,
If
sir.
it doesn't cover your client, then you don't need to produce it.
Okay. And a lot of the questions, I'm sorry, Ms. Go ahead. You're doing your presentation.
The second piece of information we're seeking from the RFP is RFP 13, which is the plaintiff's employer information. Again, we got a response that there was no documentation responsive to this request, but the plaintiff's medical records state that she was employed. I need this information to verify employer provided health insurance.
Granted.
Thank you. The third is request for production 30 seeks a completed affidavit of other insurance. The one that plaintiff attached is not complete as it lacks a social security number, the auto insurance information. It indicates she was single, though her medical records indicate she's married. So defendant requests that plaintiff re-execute this affidavit with the correct information.
You're to correct that if it's incorrect, Mr. Eason.
Yes, Your Honor.
And then finally, Your Honor, defendant asked for RFP 31, which is a signed letter from plaintiff's employer stating that she did not have health insurance. If that is in fact the case, we again got a response that they didn't have any items in response to this request. We need either an attempt that they tried to get this information or the information itself so that I can submit for settlement authority, as this case is governed by the state of Texas.
So ordered. All right. Anything else today, Ms. Voigt?
No, that's it, Your Honor. Thank you very much.
Ms. Voigt, if you could go ahead and prepare an order for me, share it with Mr. Eason. At the beginning of the order, it's very important that you, instead of say on this date, put on January 9th, 2023. Make sure you share it with Mr. Eason and then get it submitted to me if possible by tomorrow morning, okay?
Yes, Your Honor. Thank you very much.
You guys have a great rest of your day.
Thank
You
you.
too. Thank you.
Thank you. Are both sides here on the Benita Cole versus Danae Jackson case?
Plaintiff's here, Your Honor.
Defendant is here, Your Honor.
All right, let's go on the record on DC 199701 Colby Jackson. Counsel, make your appearances.
Rachel Hatton Adam, counsel for plaintiffs.
Carrie Carter, Your Honor, counsel for Danae Jackson, defendant.
Okay. So as I understand it, there's an issue as the timeliness, and then there's an issue as the sufficiency of the exhibit. Is that of the counter affidavits? Is that correct?
No, Your Honor. The issue as to timeliness, we were trying to point out that this case is an old case. It's covered under the old.
Oh, I'm sorry. I misunderstood that. I thought
one.
you were arguing that it was untimely. Okay.
Yeah, and because of the unique procedural posture that's led up to this, I wanted to again remind you of the context of our prior at least 2 hearings on the initial counter affidavits, and now we're here again with new counter affidavits for the same provider and the same types of services that the court has already heard and already ruled on. Now with new counter affidavits taking the third bite at the apple, so to say.
And Your Honor, obviously, the defendant's position is that these new counter affidavits have come in post in re Allstate, and the discussions related to the counter affidavits previously all occurred prior with different counter affiants and with different defense counsel.
Okay.
Right. However, would Your Honor like me to proceed?
Yeah, go ahead.
Okay, sure. However, despite different and new defense counsel, the facts before the jury are still the same, and what should be admissible under proper 1801 standards does not change. Here on this now, second and third counter affidavit for the same types of services, defense has filed 2 counter affiants, Doctors Bulk, pardon me if I'm butchering their names, and Dr. Rosier. Dr. Rosier controverts the charges from Epic, the pain management provider who provided the professional services, and that's where the facility charges will come from. Both plaintiffs, Van and Benita, have received more recent pain management services, including injections from Epic. They're consistent pain management provider throughout this case. And Dr. Balk is controverting the charges of the anesthesiologist. So that's how those are divided. Both counter affidavits have produced counter affidavits that do not meet the requirements of 18001F, especially when judged against now our model of in re Allstate. Noticeably deficient, what critically missing from both counter affidavits are the data that's used. What is the basis of our notice? Now, both counter affidavits, doctors say that they use a wide range of data, for instance, Medicare, Medicaid, the Texas workers, insurance, private pay, but they don't say which data is actually used in reaching their opinions, nor, unlike the in re Allstate counter affidavit at issue, do they provide the data for us to see. We are on the eve of trial, Your Honor, and this counter affidavits, I should be able to judge based on the four corners, based on all the prior rulings of what Your Honor would demand and what is required from a counter affidavit, to see the data that's used. Without that, I'm left with no notice and no way to obtain this notice as to what data is used, how it's used. Are we comparing charges to reimbursement rates? Is this an apples to oranges type of analysis? Are we using the right geographic area or time? All of these questions that are left unanswered leave plaintiffs, myself, in a position where I'm unable to plan my attack on the counter affidavits. From the court's clarification in re Allstate applied to this case, these counter affidavits should be struck for their failure to provide the essential notice to plaintiffs.
Okay.
Yeah.
Is that it?
Yeah.
Response?
Good afternoon, Your Honor. I would point out at the beginning that while this provider is not new to this case, the treatment service dates that we're discussing in the current counter affidavits at issue has been since the prior mistrial. So this case, let's go back one step. The case is currently set for trial on January 17th, 2023. It is in fact the eve of trial. And in the interim between the last trial date in April of 2022 and today, the plaintiff has gone out and sought additional treatment. So the treatment that is at issue in these counter affidavits has not been ruled on by this court. These are new charges, new services provided. The plaintiff argues essentially that the affidavits do not provide reasonable notice. As the court is aware, reasonable notice is determined by the fair notice pleading. And plaintiff has compared these affidavits to the affidavits that are at issue to the counter affidavit that is an issue in re Allstate, which was prepared by a CPT coding expert. That is different from the Rosier and Bullock counter affidavits at issue here because they are physicians who are board certified in physical medicine in the case of Dr. Rosier and anesthesiologists in the case of Dr.
Can I ask you a
Bullock.
question of the attorneys
Sure.
here? Because this in re Allstate has been a little hard to figure out what it really means. My approach, and Judge Goldstein and I used to differ on this. We talked about this extensively, and she ended up being better able to predict what the Texas Supreme Court was going to do than I was. I kind of felt like these billing experts, were that were coding experts were not appropriate experts, and I struck them pretty much every time. Prior to in re Allstate, now with in re Allstate, they kind of changed the dynamic, and it says that that obviously was not the approach the Supreme Court would have liked me to have taken prior to their ruling. What I don't know, and this is not the first time I've heard this argument, is what do we do now with what I always felt was the better approach, which is exactly what you did, Ms. Carter, in this case, which is hire a doctor who actually is an expert in this field. I would typically not strike those experts because if they were done appropriately apples to apples, chiropractor to chiropractor, if they were done correctly, I would typically not strike them. What I guess I don't know the answer to is, have there been any cases, appellate court cases or cases of the Texas Supreme Court that have discussed what do we do in a situation where you have a doctor, like you just said, Ms. Carter, which I think is a really interesting point, is, Ms. Hatton is not the first plaintiff's attorney to try to argue this, was that, well, now you have to use coding experts. Have there been any cases that have talked about that post in re Allstate, about what is the requirement if the defendant uses a medical provider as opposed to a coding expert?
Your Honor, I am not aware of any cases, and I looked recently, but I admit that I didn't look in the last week or so. Where I think that issue comes into play is when they are using their own experience, education, and knowledge in comparing the prices. So, for example, if Dr. Baluk provides the same services that is being compared to Lakewood anesthesia, then he obviously has a different data set from which to pull than somebody who is just a CPT coding expert. So that
I totally agree with you. I think this is the better approach, but unfortunately, I'm not the Texas Supreme Court. I know. So they have come up with this rubric. And Ms. Hatton, did you know of any cases?
I don't know of any cases, but I do want to clarify something that is being, I think, misunderstood. The original counter affidavit that Judge Hoffman, you ruled on twice, was the affiant in that case was Dr. Vicaria. He wasn't a billing expert. He was a pain, and is, I'm assuming, still a pain management specialist. So this is not, now the court is being asked to judge finally doctor counter affiants, trying to critique these services. It has always been doctors. Your Honor has ruled twice on prior counter affidavits from Dr. Vicaria in this case, and now is being asked
have I struck them twice? Is that what
Dr. Vicaria's affidavit was struck? For the initial substantive counter affidavit was struck. Then post in re Allstate, Dr. Vicaria tried to ask for supplement his counter affidavit because Benita, one of the plaintiffs, went back for one office visit.
I remember this.
Yes, and an essential, let's now try and retailer Dr. Vicaria's counter affidavit to address all the problems. And that still was no, although Your Honor did rule that only the newest treatment could be struck. But the original substantive counter affidavits with all the treatment thus far for both plaintiffs could stand.
Wait, the affidavits would stand, or the counter affidavits?
The 1801 affidavits would stand, the counter affidavit, no.
Okay. All right, that's helpful. Response?
There has been a lot of back and forth on this issue in this case, and I think that the court, the rulings, I lay it out in my motion exactly what happened. I think I came away from the orders understanding that the counter affidavit as to the very last epic treatment by Benita was okay, was not struck, but perhaps I misunderstood. That's possible, and I would have to go back and look at it. But there has been quite a bit of back and forth. And prior to the trial setting, and in the interest of full disclosure, prior to the April trial setting, I filed a motion for reconsideration, Your Honor, on this issue. And I don't know that it was ever officially ruled upon, although I think possibly in pre-trial, Your Honor said, I'm going to overrule the motion for reconsideration. But I just don't know for sure. That having having said all that, let me lastly say that the current counter affidavits that are before the court in the plaintiff's current motion to strike have never been before the court before.
Okay. It's hard to predict what the Supreme Court is going to do with all this stuff. So, and we have a trial setting next week, I guess.
The
Yes.
17th, Your Honor.
And let me see. I think you guys may be number one because the old case.
And Your Honor, at this point, I mean, the current counter affidavits that are before the court encompass all of the treatment that they have seen. It's not, the same question of do we get to redo and now make inadmissible affidavits of treatment that had previously been admissible and ready to go. We've got a trial setting next week, and I have no time to redepose any doctors, depending on the court's ruling. We're kind of stuck.
Okay. Why don't we say this then? I'm not going to, I think this is, kind of a brave new world we're in right now, what's happening. So, I'm going to keep my same rulings, which is I'm going to go ahead and strike, I guess, these counter affidavits. If we don't get reached for some reason, and hopefully that won't happen. What was the reason we had a mistrial the first time is, if I'm remembering correctly, somebody mentioned insurance. Is that right?
Yes.
Let's not have that happen again. Let's just see what the Court of Appeals, Supreme Court does on all this stuff. So I'm going to stick with my same ruling. I don't want to have to bump this trial setting, and we'll go from there.
All right. Thank you, Your Honor.
All right,
Your Honor.
guys. We'll see you next Tuesday.
Yeah.
Okay, bye-bye.
Bye.
Bye-bye. Okay, our next hearing is Mr. Smith. What are you here for?
I'm here on the Carlos Torres versus SAV Enterprises, Wilbur Antonio Venegas et al.
Okay, that's our next hearing. It's Tony, let's go on the record on DC 209573 Torres versus Venegas. Council, make your appearances.
Justin Smith, you're on behalf of the plaintiffs.
Keith Robb for defendant SAV Enterprises.
And
Is that
we've
it?
got another defendant, Judge, but I don't see his counsel on here. Another set of defendants, I should say.
Are they here or not? Are they subject to this motion?
They are.
Miss Jefferson, she's the court reporter. Miss Jefferson, you're here. You're back here for the 3:15 hearing
Yes, am I still early?
or 3 o'clock hearing for Crescent Ventures. Is that your case?
Let me check. Let me double check. Give me 1 second. Yes.
Okay, yeah, we're not to you yet. All right. So, Mr. Smith, Mr. Roll, what do you guys want to do about this person not being here?
I'm gonna email him right now, Judge.
Guys, give me 1 second. I'll be right back.
Of course. Mr. Rob, have you heard anything from Mr. Carp?
No, I haven't, it's been I probably only emailed him last week, so I haven't heard anything today.
Yeah, I haven't heard anything from him today either. And in candor, it has more to do with his clients than it does yours.
Yeah, if he doesn't show up, this will be a very short hearing, I think.
I agree.
What do you guys want to do? Do you want to go forward or do you want to wait for this guy?
I'm inclined to go forward, Judge, at least on a couple of issues that I think there's really not anything to fight over. And there is a lot of overlap between the discovery that's with SAB and the discovery that's Premier. And with our trial setting up on the 31st, I don't know that we have another opportunity to get in front of the court in a meaningful way on these pretty limited issues.
Mr. Carp? Or Mr. Rob, sorry.
Oh, if we're here now, I'd certainly, let's see what we can get done with now rather than coming back and doing it again.
Okay. You do have a January 31st trial setting, so let's go on the record on cause number DC 209573, Torres versus Venegas. Counsel, make your appearance.
Justin Smith here on behalf of the plaintiffs.
Keith Robb for defendant SAV Enterprises.
All right, let's proceed.
Very good, Judge. Very briefly, this case involves Mr. Torres, who was working in a remodeling project for a pawn shop that had been recently acquired by SAB and leased to Premier Option Credit. During the remodeling project, gasoline was used as a solvent and the vapors ignited, catching Mr. Torres on fire. As the court just mentioned, we have a trial setting in this matter on January 31st of this month. And we have filed a motion setting the defendant's objections predominantly for Premier Option Credit, which is the pawn shop company that is represented by Mr. Carp, who's not present. Although there are a couple of requests that are directed to SAB Enterprises, and then the issue of verification of interrogatories. And we set those objections for hearing, and then upon a ruling from the court on those objections, move to compel responses. And it basically boils down into 5 categories of things. Number 1 is the interrogatory responses for both SAV Enterprises and for Premier Option Credit are not verified. So we just need verifications from the entities on those interrogatories. And
Those
then
are ordered to be verified.
Number 2, Judge, is with respect to both SAV and Premier, 3 requests for production that ask for the financial records, receipts, documents that show what was purchased in the month prior to the fire in regards to this renovation and remodeling project. And then only with respect to Premier Option Credit, there's a couple of interrogatories about employment documents because there's an
So
issue.
let's break this down. I have an order here. See if I can share screen it.
Of course,
Excuse me. You guys see this okay?
we do.
Yes,
This
Your
is the order that you wanted me to look at?
It is.
Okay, so let's kind of go through the order. So we so who is the attorney that's not here? Is it the attorney for save or for option credit?
For option credit.
Right, all of their objections are overruled. Let's just, since they didn't show up. So the ones involving, according to this order, the first one is
Just 1, 2, and 3.
1, 2, and 3. Okay, so what are those about?
That is receipts, bank records, credit card statements for the purchases made by SAV in the month prior to the fire.
Response?
So what I'm predominantly objecting to in these requests is that they're broad in the sense that they ask for all of the documents on this topic. I have produced documents that show what SAV Enterprises spent in the time period. But I think that digging up every single document that shows that same amount of money is overbroad, and that's essentially what I'm objecting to.
The first question I have is that in the title, it said, in the style, it says SAV is spelled SAV, but down here it's SAVE. Is it SAV or SAVE?
That's a typo. It is SAV. It's an acronym for Sabino and Antonio Venegas, I believe.
It's just hard not to type SAV Enterprises.
That's right. All right, I'm going to go ahead and overrule those objections. Then we have defendant Venegas. Do you represent him, Mr. Rob?
No, sir. Mr. Venegas is related to Premier Option Credit.
Okay.
It's also represented by Mr. Carter.
All right, so that looks like it's the only thing related to SAV is I've already ruled on, it looks like.
That's correct. Other than the verification, that's the only thing.
And I've ruled on the verification, so
Yes, sir.
how quickly can you get this compliant? Well, you have a trial setting coming up, so I'm gonna give you 7 days.
Okay. Well, I can comply with that, Your Honor.
I suspect there's really not much in the way of documents that are responsive. It's just a matter of cleaning it up and making sure that nothing's obfuscated under the objection.
Your Honor, I think since next Monday, I think might be a holiday. Can I have till Tuesday? Is that the 7 days?
8 days is fine.
Okay, thank you.
I just changed it. All right, anything else, guys?
No,
Your
Your
Honor,
Honor.
just-
Let's chat just real quick. So the trial setting's coming up. Let's kind of look at real quick, kind of where you are on the docket.
Yes, sir.
You have some feel for it. I mean, this case is pretty old, so you think, is this on the 31st? You said on January 31st?
Yes, Your Honor.
So the week before, we have a special setting on a pretty big case. They tell me this case is going to go 10 days if it goes. It's a non-jury, so that's pretty unusual for a non-jury to go that long. But there is a decent chance that you guys will get bumped by the special setting from the week before. So do you want the contact information for those attorneys just so you can chat with them?
That would be lovely, Judge. Thank you.
So the name of the case is ARM, ARM, Energy Management versus Medallion Pipeline Company. And the attorneys are, looks like Kate Shih, S-H-I-H, and Landon Smith for the plaintiffs. Let me see if I can get some contact info. Kate Shih is with Quinn Emanuel out of Houston. Phone number is 713-221-7000. And Thomas Patterson, in case you want to call him, is 713-653-9366 with Sussman Godfrey. So they're telling me that case is going, 2 weeks. So if that is the case, then you guys will get bumped, but there's no guarantee it actually, but it is specially set. So if you guys, so right now on the docket, I'm sorry, I'm looking at the wrong week. On the 31st, you are the number 2 case that week, and there's a case ahead of you, it's like a car wreck. Let me see. It's a car wreck case, and the plaintiffs are the plaintiff, it's Jeffrey versus Uche, U-C-H-E. Plaintiff's attorney is Christopher Held, H-E-A-L-D, with the Held Law Firm. And his phone number is 469-598-1900. Defense attorney, you may have had cases against them, is Gregory Scott. His number is 214-951-9292. So I think those 2 cases are the most likely to stand in your way. So it's always possible some other case from the previous week could go over, but I don't think so. So, all right, guys, any other questions?
No, Your Honor.
You have a
No,
great
Your
day.
Honor.
All right, thank you, Your Honor.
Thank
Thank you, Your Honor. Appreciate you.
Thank you too. Bye-bye. Tony, our next one is let me just double check it.